Hi there, this is Jonathan Ginsberg. I'm an Atlanta area Social Security disability attorney. And today I'd like to talk to you about the three biggest mistakes to avoid, the three biggest mistakes I see in my Atlanta area Social Security disability practice. And these are things that I've seen over the years. I've been doing this for 25 plus years, and the same problems keep cropping up. And if you can avoid these, your chances of winning are going to go way up. First thing is you want to be very, very specific when you describe your limitations. Social Security defines disability in terms of your capacity for work. Specifically, how does your medical problem prevent you from being a simple employee at a simple entry-level, unskilled type of job? That's the way they define disability. It's about work activity. So you want to be very, very specific. So instead of saying, I can't lift very much, you want to say, I can lift 5 to 7 pounds. Instead of saying, I can't stand very long, I can only stand for about 10 minutes and I need to sit down for 15 minutes before I can stand up for 10 minutes. The total amount of standing I can do in any 3-hour period is about 20 minutes. Or I can sit for 15 minutes at a time, then I'm going to stand up and walk around for 7 to 8 minutes, then I can sit down again, but I can sit for no more than 2 hours in the course of a day. The rest of the time I need to be in a recliner with basically stress off my back. The reason you have to be that specific is that when you get to a hearing, the judge will have a vocational witness who will try to identify jobs that you might be able to do. And so if the judge says, Mr. Vocational Witness, we have an individual here who can only sit for 10 minutes at a time, and then he needs to take a 7-minute break walking around away from the work site, then can come back and sit another 7 to 10 minutes, but can only sit for a total of 2 hours in the course of a day. What does that mean in terms of his work capacity? That's a specific question that a vocational witness can answer. But if the judge says, we have an individual here who can't sit very long or stand very long, what does that mean? It doesn't mean anything. Vocational witness is going to say, what does it mean to say not very long? So the more specific you can be, both in filling out the forms and in testifying, the better it's going to be for you. And one of the things I spend a lot of time with my clients doing in preparation for the hearing is asking and answering those kind of questions so that my client is going to be very specific. And I tell my clients, if you're at a hearing and you start getting into not very much or not very far, not very long, I'm going to stop you. I'm going to say, Mr. So-and-so, I need you to be more specific. What does not very long? How long is not very long? How far is not very far? Because the more specific you can be, the judge can plug that into a potential job description and ideally come to the conclusion that you could not fulfill the duties of that job description. But you have to be very specific, and you've got to train your mind to be very, very specific in that regard. Second thing is, if you have a medical condition, and let's say you've got a herniated disc, or you've got a DVT, or you've got a diagnosis of schizophrenia, the diagnosis alone is not going to be enough to win your case. You can have a herniated disc and still function at a job. You need to go beyond that. You need to go and describe specifically how that herniated disc, how it developed, the type of treatment you underwent, were you compliant with the treatment, and how that treatment has not been successful in restoring your function. And again, like I just talked about, being real specific, you want to talk about how this condition, this medical issue, what that means in terms of your work activity limitations. Again, Social Security disability is about work activity. So you want to talk about how your medical problem interferes with your work activity, the actions you would take at a job: sitting, standing, walking, climbing, lifting, kneeling, stooping, crouching, ladders, ropes, scaffolds, that sort of thing, attention and concentration, memory, behaving in an emotionally stable manner, getting through a workday without emotional distress, need to take unscheduled breaks. How often would you need unscheduled breaks? How many days of work would you be likely to miss? It's all very, very practical. This is not about, I have a herniated disc at L5, S1, therefore I'm disabled. that is not enough. You've got to take it beyond that and explain to the judge, what does it mean in terms of your functioning to have a herniated disc, to have a DVT in your leg, to have a diagnosis of bipolar? What does that mean? What does it mean to be severely depressed? What does it mean to have PTSD? What does it mean to have congestive heart failure? How does that affect your activities, your interaction with people, your capacity to function both at past work and even a simple entry-level job? That's what we got to focus on. So being very, not just specific, but talking about how your limitations affect your capacity to function in a potential job, in a job-like setting, in a work setting, that is really, really important. And the third thing that I think people get messed up on, and you should really try to avoid, is having an attitude of entitlement. No question, if you are filing for disability, you're uncomfortable. You may be in a lot of pain. You may have difficulty remembering things. Or you may have severe depression, or you may have severe back pain. But you can't go into a hearing saying, "Judge, I'm disabled, pay me." You want the judge to make that conclusion himself, but you want the judge to see you as a fighter. I don't want to be here, Judge. This is the last place I wanted to be at age 43 or age 56. I'd rather be working. This has been extremely frustrating to me because I can't support myself. I've got to depend on my grown children to pay for my groceries. It's extremely frustrating. If I could get better, if I can get a surgery or treatment to get better, I'm back out working. I don't want to be here. I'm fighting this every step of the way. That's a much more credible place to be than to say, well, I know I'm disabled, or, that happened to me before I became disabled or after I became disabled. That's the decision, whether you're disabled or not. That's a decision for the judge. You don't make that decision. That's a legal conclusion for our purposes. So you want to go in with the idea that you're not disabled, that you're fighting the idea, but that you turn to disability, Social Security disability, as a last resort. And if you have that attitude that you are fighting this every step of the way, judges pick up on that. They want people who want to go back to work. They want people who are fighting the idea of being disabled and find it demeaning and repugnant. And that's really what that's the attitude judges hope to see. And so if you go in with the right attitude, that you are fighting this every step of the way, that you don't want to be here, that will help you with credibility, and that's a big part of this. The judge is going to find you believable, and you have a greater chance at winning. I have had clients win cases that I thought were somewhat marginal. I remember one case in particular where a client had listed 5 or 6 things that he said was wrong with him, and the judge was asking him about, let's say, one thing, I think it was a problem in the shoulder. My client said, well, Judge, to be honest with you, my shoulder has gotten better. I don't think that's a disabling condition. I can still use my shoulder. But the problem he had in this case was PTSD. And so he talked about his physical issues. His shoulder was okay. His back had gotten better. So he basically took 2 or 3 things off the table. And I could see the judge looking at him saying, nobody does that. But the fact that he would do that says to the judge, he'd rather be working. He's not trying to say that everything is wrong with him. And this guy won his case because he was so believable, because he was prepared to take things off the table that were no longer bothering him. So that's sort of just a tip that I picked up over the years, that if you show the judge that you're fighting the idea of being on disability, that can go a long way of proving that you're a believable person and help you win disability, especially, obviously you want to be sincere about it, but especially if it's a situation where you've got, let's say, something that's improved, or that you are showing that you've done everything possible, every type of treatment possible, even things that could be dangerous. You've done them because you want to get better. So those are just 3 thoughts about things that have worked for me over the years, things I advise my clients. And I think that if you keep those things in mind when you go to your hearing, your chances of winning are going to go up, because a lot of people, frankly, don't do it. They go in with the idea that they are disabled and they want to get paid, or they talk in generalities, or they don't really talk about work capacity issues. Those are the things you got to do. And if you do those things, no guarantee you're going to win, but it's going to improve your chances at winning, and certainly I hope that that does happen for you. My name again is Jonathan Ginsberg, and I hope you found this video helpful. If you did, I'd be grateful if you would give it a thumbs up on YouTube and like it on our Facebook page. Subscribe to my YouTube channel and like our Facebook page. You'll see I've got a lot of videos coming out, a lot of things that I think you'll find very, very useful. And if you subscribe, you'll get notice about all those type of things. You can go to my website, which is SSD, like Social Security Disability, ssdanswers.com/. /Atlanta, and you can get a lot of information there about Atlanta disability cases. You can also get my free Secrets to Winning Disability Survival Kit. A lot of good information there about how to win, things I've picked up over the last 25 years that have worked for myself and my clients. I think you'll find it very useful, delivered by email, no cost at all. And if I can be of help to you, my phone number, direct phone number here in Atlanta, 770-393-4985. My email, personal email, Ginsberg, my last name, Ginsberg @gmail.com. I cover the Atlanta area hearing offices, Atlanta, North Atlanta, Covington. I'll go to Rome, Gainesville, Athens, Columbus, Macon. I even go to Chattanooga, Rome. So anything in North Georgia. And if I can't help you, if it's out of my jurisdiction, out of my area that I go to, although I do travel sometimes, but if it's outside of someplace I'll go, then I'll get you to somebody who can help you. So again, my name is Jonathan Ginsberg. I do hope you find this helpful, and please let me know if I can be of assistance to you. Leave me some feedback, and I'll see you next video. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the survival kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.